Let's face it, copyright and permissions are not the most exciting topics. But if you were thinking about writing a book, are in the process of writing a book, or are looking to get your book published, then watch this video for some copyright facts you need to know to enhance your success. Did you know, in most cases, the original creator of a work or the company who hires a creator under a work for hire automatically holds the copyright to that work? Neither a copyright symbol or copyright registration is needed, although it is a good idea to give notice that your work is protected by copyright laws. Copyright owners have the exclusive rights to copy, distribute, perform, and display the work, and the rights to create derivative works, like an audiobook, screenplay, or movie. Just as you want to protect your copyrights, so do others. Writing a book with only your original content may be your best protection against copyright infringement claims from others. Any content created by others is considered third-party content. However, you do not need to create everything yourself, and you can legally publish a book that includes third-party content by following certain rules. You have worked long and hard to write your book, but when submitting to a publisher, you must have permission for any third-party material which you did not create. This includes, but is not limited to, text excerpts, photographs, artwork, illustrations, screenshots, cartoons, charts, music clips, video footage, and performances. If you are not the creator of everything in your book, then you will need to prove that you have permission from copyright owners or have valid licenses to use their content. If you infringe even a little, whether knowingly or not, your book can be taken down, removed from shelves, or you may be sued. An exception to copyrights is fair use, which is often misunderstood. Under the fair use doctrine, certain materials may be used in limited circumstances without permission. There are 4 factors that govern fair use exception. First, the purpose and character of the use. Second, the nature of the copyrighted work. Third, the amount and substantiality of the content. And fourth, the effect on the market for the copyright owner. You may be able to invoke the fair use exception for commentary or criticism, a parody, news reporting, scholarly research, and educational use. If in doubt, it is best to flag content for review and consult with your publisher or your own attorney. It is always safest to request permission to avoid legal issues later on, since fair use ultimately is something a judge will determine. Another exception to copyright law is public domain. Works in the public domain do not need permission for use. These are works where intellectual property rights have expired, have been forfeited, or are not applicable. Examples include the works of Shakespeare and Beethoven. In the United States, works created prior to 1923 are out of copyright. If a work was created in or after 1978, then it enters the public domain 70 years after the death of the author, or for works for hire, 95 to 120 years from its creation. While many works published prior to 1978 are in the public domain due to failure to adhere to copyright formalities, a good rule of thumb is that those works are protected for a period of 95 years after initial publication. Works created by the U.S. government or officials in their government capacity are considered public domain. So, for example, speeches by the President or Congress are both public domain. Works in the public domain can be protected under other theories. For example, the title of a public domain work can be protected as a trademark even after the book falls into public domain. Company logos and designs, especially cartoon characters, can survive the plunge into the public domain if they serve as trademarks. Complying with copyrights is serious stuff. Publishing a book in print or digital media formats without proper permission at minimum may result in a takedown notice to your publisher or removal from bookshelves, and may result in your publishing contract being canceled. This may damage your reputation as a writer and may result in loss of income. It may also result in a copyright infringement lawsuit not only against you, but your publisher as well, with money damages up to $150,000 per infringement. Copyright law can be complicated, so we invented a rights assessment app that can help. Using your iPad, tablet, or PC, just enter information about your book, answer some simple questions, and get your instant rights assessment checkup. You will receive a rights evaluation report indicating your risk index. And if you need permissions or licenses, the Digi-Rights app can help with that too. Taking the rights assessment helps you and the publisher identify the content in your book, providing a systematic way of determining what material you own, what material may be fair use or public domain, and helps with third-party material, giving you the option to automatically get permissions or licenses from the rights holder. Knowing your rights expands the market for selling your book and reduces the risk of losing your hard-earned income or even a lawsuit. The rights assessment gives you and the publisher added protection, opens the door for more sales, and may be the best investment you make in your publishing future. So go ahead, click on the link below to find out more about your own rights assessment.